Andy Halaby is a trial lawyer with Snell Wilmer in Phoenix. He's a former professional engineer, which makes him very dangerous, focusing on technology litigation, including infringement, unfair competition, cyber piracy, trade secret, and deceptive advertising cases. As we all know, every company's intellectual property is the cornerstone of its shareholder value. Challenging that value has been in a variety of patent trolls, people who attempt to enforce patent rights against alleged infringers far beyond the patent's actual value. Andy will discuss how to deal with such attacks. Please welcome Andy.
Good morning. It is true that I was an engineer in a prior life, and I have since come to focus my practice on intellectual property litigation of a variety of types. But I began my career as a business litigator and continued to be a business litigator and trial lawyer. And an issue of continuing interest to me, and I hope to introduce it to you as an issue of interest, is the degree to which patent litigation and the seismic changes that are taking place in the patent litigation world actually are rippling out into the day in, day out business litigation experiences, outcomes, ways of thinking of federal district judges and business trial lawyers of all types. So let's talk after the presentation, and you can tell me whether you see some resonance there. I'm going to begin with patent trolls. I know that the subject of patent trolls is now a well-known phenomenon, and so I'll touch on that subject as such only lightly, but I'll talk to you about three ways in which trolls and troll activity have manifested themselves in changes in the law or potential changes, legislative, case law, rules. And then I want to talk about some substance. I want to talk about how the economy and our business is being impacted by these activities and the responses to them. So let's begin with a brief word about patent trolls. Justice Kennedy first mentioned patent trolls explicitly in his concurrence in a significant 2006 decision called eBay versus Merck Exchange, and we've now undoubtedly had clients that have encountered patent troll activity. Of course, as I've noted in the paper, including your materials, the definition of a troll can be a little bit problematic. We all think we know one when we see one, but of course, if that entity, that company that happens to have patent rights that company wants to enforce for money, and it's our client, it gets a little more uncomfortable to call them a troll, and I personally think that's because the patent system is designed to yield intellectual property rights, inventive rights that can be freely traded in the marketplace. And while it seems dastardly to wield patent rights and flex the litigation system just to get money because it's more costly to defend than pay, on the other hand, those patent rights had real value to someone because they were traded on the open market, and our clients sometimes got them. In any event, Congress has before it a variety of bills that are designed to address the patent troll problem, to the extent it can be fairly characterized as a problem, and I wanted to talk to you about a handful of those acts. I will tell you that my wager, if I were going to put a wager down, is that none of these will pass this year. There was a strong wave of support for the first one, the Innovation Act, last year. This is the one that's sponsored by Representative Goodlatte from Virginia, and the Obama White House signaled that it would support that legislation if it got through the Senate, but it didn't. The Strong Patents Act is actually a reaction, a pro-patent reaction to the Innovation Act, sponsored primarily from Senator Coons from Delaware. The third one you see there, the Patent Act, is Senator Grassley's proposal. It's a diluted version, a less anti-patent version of the Innovation Act. Then you have the Innovation Protection Act. This is John Conyers' proposal. And this one is interesting because it addresses the what it views as the root of the problem of too much patent litigation by saying, you know, if Congress weren't diverting fees that the Patent and Trademark Office brings in order to prosecute patents and instead use those fees to enhance the quality of patents issued by the Patent and Trademark Office, a lot of these other problems would wash away. And there is something to that proposal, I think. Finally, the Troll Act is a fifth proposal which is designed, in essence, to require patent infringement demand letters to have more material. So let's look at some of the provisions that these various pieces of legislation include. One is fee shifting. As you may be aware, right now under the patent laws, it's only in exceptional cases that patent fees can be awarded. So the norm is the American rule still, that each party bears its own fees, win or lose. Under various of the proposed legislation, it could either shift to a presumptive loser pays rule or a loser pays no matter what rule, and that would have a significant impact, I think, on how much patent litigation we experience. We have heightened pleading standards proposed under current law. One doesn't need to say much about the accused product or the particular claims that the plaintiff claims were infringed. A third interesting component of this proposed legislation is the customer stay provision. Patent trolls often target downstream, relatively small users of the patented technology, thinking that they will be more inclined to write a check to settle rather than fight. And so bullet point 3 there, this customer stay provision is designed to say, no, I'm going to stay such lawsuits. The district court's going to stay those lawsuits, forcing the plaintiff to go after the ultimate supplier of the technology. Of course, that's simpler than it sounds clearer than it really is, especially when the ultimate supplier may be a foreign company that's beyond the reach of the United States patent laws. Again, some requirements for additional detail in demand letters, which raises interesting First Amendment implications. And finally, the possibility of staying discovery pending resolution of dispositive motions, dismissal motions, which of course, if passed, means that every single patent infringement case will begin with a motion to dismiss, whether it would have otherwise or not. Let me turn from potential legislation to case law. As you saw in the article in the materials, the Supreme Court has been very active in the patent space of late. Over the last 10 years, we've seen something like 30 cases, where in the 20 years before that, there were 7. And there are a couple of reasons for this phenomenon. One is, I would offer to you the path that the Federal Circuit Court of Appeals has taken in attempting to be what is supposed to be the court of last resort on patent issues. As many of you know, in 1982, the Federal Circuit was created in order to help develop a more uniform body of patent law. The perception in the late 70s and early 80s was that the United States wasn't respecting patent rights enough, and that having patent law issues determined by the various regional circuit courts of appeal was breeding disuniformity and eroding the economic value that the economy might otherwise be able to attain from inventions. Now, what you see is that the Federal Circuit has, in the ensuing years, in various manifestations, some of which we'll talk about, developed hard and fast rules interpreting the patent laws. And the Federal Circuit has done that essentially because it has to guide not only litigants like our clients, but it has to guide inventors who actually apply for patents. And those inventors do better with hard and fast rules than they do with amorphous standards applied after the fact. Nevertheless, in this series of decisions, which you see dealt with in more detail in the materials, the Supreme Court has time and again reached out and said to the Federal Circuit, no, 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 Federal Circuit, you are being too rigid, you are being too pro-patent, and we're going to rein you in and either insert a more anti-patent standard, and/or we're going to make the law more muddled, almost on purpose, with a view toward discouraging the filing of patent infringement suits. One of the ways you see this activity at the Supreme Court level manifesting itself comes in bullet point 3 there on fee shifting. There were two decisions by the Supreme Court last year, one in Octane and one in Highmark, which were designed to take the law from being almost completely anti-fee shifting under the exceptional case standard and replacing that very American rule approach of the Federal Circuit with a rule that says it's really up to the district court, and if in all the circumstances the district court thinks that fees ought to be shifted, then the district court can. The entitlement to fee shifting needs only be proven by a preponderance of the evidence, and we're only going to review that decision by the district court in an abuse of discretion standard. We see even for example, this year in a case called Terra versus Sandoz, the Supreme Court saying that it was going to require the Federal Circuit to be more deferential, not less deferential, to district courts when they are construing claims, which is the term of art in the patent world for determining what the patent actually captures. Let me turn to the Federal Rules of Civil Procedure. Everyone in this room remembers the Twombly and Iqbal decisions, which are now approaching, they're not quite a decade old, but they've been around a while. And as I look around the room, I think a lot of the people in this room actually remember and use the Conley versus Gibson no set of facts standard for motions to dismiss before Twombly and Iqbal. Thoughtful business litigators and thoughtful trial lawyers read Iqbal and Twombly and thought, that's interesting. I suppose it's good for my client. Typically, for our clients, it was good news that the Supreme Court is trying to rein in filing of litigation by requiring plausibility, more detail in complaints. The problem was that there was this form, or there were these forms authorized by Rule 84, which showed what sample complaints look like. And they said, in essence, whatever the words are, whatever the claims are, these are as detailed as you have to be. You don't have to be any more detailed. It was sort of like a picture's worth 1,000 words. And so in this case, bill of lading, the Federal Circuit adopted that reasoning and said in the patent infringement world, thank you, Supreme Court, for giving us Iqbal and Twombly, but we have a form authorized by Rule 84, and it says what's enough detail, and we're going to follow that since it's the law, according to Congress, until someone changes that. So sure enough, as of December of this year, the forms adopted or authorized through Rule 84 are disappearing, unless Congress says otherwise, and Congress won't. Poof, they're going away. And so this is an example, I think, why you wouldn't find it in writing anywhere. I think it's fairly clear that if we look through the mist and see why these forms are disappearing, there is a kernel of patent law influence in the economy, or in the courts and Congress's treatment of this issue, because it was, I think, to a degree, the refusal to apply Twombly and Iqbal in the patent context that led to the activities that ultimately lead to Form 84 and the forms disappearing. So the procedural changes wrought by these patent cases aren't limited to the disappearance of the forms from the federal rules. We also had the eBay case's decision that permanent injunction standards in the traditional time-honored way are going to be applied in the patent context. That rule has now been applied in the trademark context. It's been applied to preliminary injunctions as well as permanent injunctions. We also have the reality that federal district judges are, I think being given two opportunities to think afresh about all the different kinds of cases they handle, and not just patent cases, because decisions like Octane and Highmark are in essence fighting the perceived patent troll problem by vesting district courts with more power and more discretion. So in an interesting way, district courts who have to handle these cases, I think, are being cloaked with the sense that they have more power and more autonomy to decide things their own way than perhaps they thought before. I also think that And the format doesn't allow me to ask for a show of hands, so I won't. But we've all confronted the situation where we are litigating a case in a federal district court, and we know the Supreme Court has decided something different than the prevailing wave of intermediate appellate court law as it exists at that time. And so you're in this difficult situation where you're trying to tell your district court judge, no, judge, the law is X, because you know the Supreme Court has come pretty close to saying the law is X, but there's still all this extant Circuit Court of Appeals law that says Y. And so I would suggest to you that one tactic you might consider using if you find yourself in that situation is to take a look at the cases that appear in the paper, or give me a call and say, can you help us draw an analogy to what's been happening in the patent world? Because the patent world is the starkest, I think, example now of an instance in which district courts can very readily be persuaded to step past an intermediate court of appeals statement of the law as it currently exists and to go straight to what that law really is decided by the Supreme Court. I recognize that drawing analogies from patent cases and other kinds of cases is something that might not feel comfortable in the first instance, but you can do it, and you can do it successfully. Now, I want to say a word about the impact that these changes are having on the underlying business climate of the country. There's a lot of movement afoot, I think, and I think you are current if you think maybe enough has been done. The anti-troll wave continues to hit the press. There are certain business interests which have a stake in continuing to promote the patent troll problem as a major problem. But certainly district court judges are tending, the ones that I've heard and talked to, are tending to line up in favor of thinking enough has been done. Because some of these proposals, like forcing district court judges to automatically stay, or to essentially automatically stay matters while a dispositive motion is pending, or to permit a lawsuit against an upstream supplier, remove case administration power from the district court due to a problem that may not exist in practice. It's also true that this is an innovating country, not a copying country. And so I think that those of us who represent companies that have substantial vested interest in intellectual property protection in the form of patent rights would be well served to consider whether our companies are taking full account of these changes and whether the financial condition that they are presenting to the marketplace continues to be accurate. I understand it's very difficult to quantify the things that I've talked about here, but in many instances, I think it's a reality that patent rights owned by a company may be worth less today than they once were because of all these changes, and it's worth thinking about from the perspective of being subjected to liability under the securities laws. And with that, I'll close, and I thank you for your time.